Hello and welcome, I'm Oles Gerjuk and you're watching Head to Head with UATV. The Verkhovna Rada of Ukraine adopted a bill in the first reading which returns criminal liability for illegal enrichment and introduces a civil confiscation tool for unjustified assets of officials. A total of 316 MPs supported the draft law. To discuss this, we welcome to our studio today Sasha Drik, anti-corruption expert and activist. Hello and thank you for joining us today.
Hello.
So at first the draft law looks quite an achievement, especially taking into account that the former political elite was trying to block the criminalization of illegal enrichment, but there are some moments that sound a little bit maybe controversial or interesting and worth of discussion. As an expert, what is your impression about this draft law? How beneficial is it?
Well, first of all, even though it's primarily referred to as the law on illicit enrichment, it's the major part of this draft law concerns the issue of civil confiscation.
Could you please explain what is this tool?
Yes, of course. So basically, what is being done? Some thresholds are introduced in terms of when civil confiscation or criminal liability for illicit enrichment can be applied in a particular case. If a person, a public official, cannot explain the origin of the assets worth more than around 1 million hryvnias, then this person is subject to civil confiscation. Mm-hmm.
And dismissal, probably.
And dismissal, yes, correct. And if a person a public official cannot explain the origin of assets worth more than 15 million hryvnias, then this person is subject to criminal liability for illicit enrichment. So this is basically the very simplified idea of this draft law. I would say that the tool of civil confiscation has never existed in Ukrainian legislation before, and this is the first time when it is being introduced in this way. Mm-hmm. The idea is something that we cannot understand in full details until it's being implemented. Mm-hmm. But in general terms, yes, you were asking about the details of the civil confiscation. In general terms, this draft law gives possibilities and tools for law enforcement, specifically anti-corruption law enforcement, to gather evidence that would basically build an argument that a certain public official cannot explain the origin of his assets. Second, it creates a more quick procedure for confiscation of these assets without the necessity to wait until the end of the criminal investigation. Mm-hmm.
So there would be a court decision, but we don't have to wait until the final ruling of the court.
There will always be a court decision, mm-hmm. But there is no need to wait until the end of the criminal investigation. And if within the criminal investigation, the criminal proceeding, there is no enough evidence to prove that certain public official can be brought to criminal liability, then the procedure of civil confiscation can be applied.
So, as far as I understand, civil confiscation is a tool, but it's not versus the criminal liability. It's one of the tools just to maybe to fasten the process, the court process, and maybe the punishment or the responsibility, the penalty being implemented for the offender. Am I right? Because the second case of the civil confiscation is about when the person is exceeding 15 million hryvnias of unexplained and unjustified financial benefits or maybe some kind of assets. And in that case, a person faces criminal liability and faces for up to 5 to 10 years imprisonment, right?
Yes, basically this is an alternative liability in those cases where a person cannot be brought to justice based on the evidence gathered within the criminal investigation. So there might be, just to give you an example how it might work, there might be a criminal proceeding where law enforcement might not be able to prove the guilt, yes, the guilt of a person, but they have enough evidence to say that this person cannot explain the origin of their assets. And in that case, there is a separate, basically, it's a separate case, so it's being separately brought to the court, and the court decides it separately. The law, the draft law, however, has a provision saying that those evidence that have been used to prove the unjustified origin of assets cannot be used within the criminal investigation. So basically I would say that there is a number of cases where the civil confiscation can be used. First is the cases that were closed because of the decision of the Constitutional Court. Those 65 cases investigated by NABU.
From 2015, yes?
Yes, from 2015, based on the article on illicit enrichment that was cancelled by declared unconstitutional by the Constitutional Court. So this procedure can now be implied by, to this people who were subject to this investigation, and their assets can be confiscated, and if they still hold a position in the government, they can be dismissed from this position. Second, are the cases opened obviously after the adoption of the law, and third, in cases where under some particular reasons were closed, but the law enforcement has gathered enough evidence to imply the civil confiscation procedure.
This is very interesting, but what do you think about this 15 million threshold that basically criminalizes the illegal enrichment?
Well, the draft law has no justification for this amount, for this particular threshold. And to my opinion, this is too high. It can be reduced, and there were some alternative draft laws registered by other political factions in the parliament, suggesting to reduce the threshold to at least 3 million hryvnias. So it can be negotiated and discussed in the parliament before the draft law is
fully
voted
adopted
in the second reading, yes.
That will be interesting to observe and to watch that talk. But the very last question, because unfortunately we run out of time, what do you think about the powers expansion of all the anti-corruption law enforcement bodies, especially a National Anti-Corruption Bureau?
Well, obviously NABU will probably become the only institution in Ukraine that will possess that much of information about the assets of public officials in Ukraine. Nobody else has ever been granted such powers. So this can be a risk, especially in terms if these anti-corruption institutions become dependent on somebody or politically dependent. So there might be a risk if we're not able to protect these anti-corruption institutions from any influence from outside. Second, I would say that because this is a new tool, completely new tool. It does exist in other countries, but this is a completely new tool to Ukraine. We cannot predict in all possible details how this will be operated by law enforcement. I would say that there might be some cases where some other amendments might be required for the law.
Well, let's wait until the second reading starts, and well, hopefully, finally, the illicit enrichment is again criminalized in Ukraine. Thank you so much for your talks, and thank you for being a guest today in our studio. That was Sasha Drik, anti-corruption expert and activist. Thank you for watching Head to Head. I'm Ola Skirjuk. Goodbye.